which is the need of the hour with our prominent experts on plugging the leaks, giving more teeth to anti-piracy fights. Now, we all know that the shift of organized content from theaters to OTT platforms with the advent of new technologies has also increased digital piracy, as these platforms don't come for free. So, to combat, or we can say to talk on the solutions to combat digital piracy, we have with us our esteemed panel of panelists. Yes, we have with us our speakers. We would like to welcome Ms. Anamika Jha, who is the founder, attorney for creators. Welcome, ma'am. Along with her, we have Mr. Anil Lale, General Counsel, Viacom 18. Very warm welcome to you. Ms. Tanu Banerjee, partner, Khaitan and Company. Welcome, Tanuji. Mr. Vishnumohan Rethinam, partner, Remfry and Sagar, is with us right now. We would like to welcome you, sir. And to conduct this session, we have Ms. Aazmeen Kasad, advocate and professor of law with us. Aazmeen, very warm welcome to you, and I would kindly request you to proceed with the discussion.
Thank you so much, Namita. So at the very outset, good afternoon to everyone, and a very warm welcome to our esteemed panelists. Content piracy, whether for songs, movies, art, or even newspaper downloads, has been a challenge since decades. But last year, since the time that the lockdown has happened and theaters were shut down, consumers and film producers have increasingly resorted to releasing their films on the OTT platforms and pay-per-view sites. Now, this has led to, obviously, while great content has been released on these sites and on the OTT platforms, this has led to an increase like never before on content piracy. So we have with us today a slew of eminent legal professionals, both those who practice in-house in companies and those who are professionals with their law firms. My first question is to you, Anil. In your experience, are the Indian laws adequate to prevent and deal with the privacy issue that you have experienced by content creators?
Thank you, Aazmeen, for the question, and thank you, Advili, for bringing into focus such an important issue as far as the creative economy is concerned. Why I say that it's very important is because the content piracy, as we see today, is basically become a parallel economy to the actual creative economy that we see through OTT platforms, broadcast, television, and all those things. When we come to the question of whether the laws are adequate, all of us know that we have the Copyright Act of 1957, which deals with infringement of works. It makes the distribution of infringing works of copyright illegal and punishable. But is it adequate when it comes to piracy? Well, I mean, this was adequate when it was dealing with, the Copyright Act was only dealing with physical means of piracy like DVD sales and cable piracy and all those things, because all the perpetrators of this kind of piracy was within the limits of the jurisdiction of the laws in India. Today, with the increase in bandwidth and proliferation of internet into the masses, and moreover, the compression technologies have become so advanced that even through social media messaging platforms like WhatsApp and Telegram, a whole movie can be shared between people. So the kind of piracy that we are talking about has clearly outpaced the development in law as we see today. Digital platforms actually is in. I was reading in one of the reports that digital platforms, like all the OTT platforms that we see today, is losing more than 30% of their revenues to piracy. There are, when we talk about piracy online, it is not just about downloading content through using BitTorrent or something like that. That time is passé, actually. Right now, we are looking at super aggregator piracy apps like Hope TV and Oreo TV, which aggregate content from all platforms, like, let's say, Hoot, which is owned by Viacom, or Hotstar, Netflix. Everything is available through just one pirated app, and they are just giving it away for free. So this kind of piracy has created a parallel economy without any investments. As India, another KPMG report I was reading was saying that India is moving toward 1 billion screen in 2028. And the level of piracy is expected to increase significantly. If the law is not fast enough to keep up with it, it is going to destroy this economy or actually dilute it to a great extent. The last amendment to the Copyright Act, also, if you see, was in 2012, where Section 65A and 65B was brought in, basically to combat digital piracy. That those were small steps that were taken, which basically says that circumvention of any technological measures applied to protect the rights and removal of rights management system is illegal and is punishable. But however, this, in my view, is a long way even for denting online piracy as we see today. First thing that we need to understand is that what we see as online piracy today is not infringement, just infringement. It is infringement, but it's not just infringement. Piracy is the business of infringement, and the website and apps which predominantly peddles pirated content is what is creating the creative economy today. Further, piracy is only the tip of the iceberg. If you look at piracy as just one crime, it is actually the tip of the iceberg, because it obviously it also finances other illegal activities and organized crimes, and also stealing of private information. Because whenever you download an app which provides pirated content and all, it actually is also stealing private information about the people who's accessing it and all the information on their devices as well. These pirates have no face, no territorial boundaries. And while our laws and enforcement mechanism is bound by jurisdictional boundaries, and some of the pirates who are outside India and is providing content into India, we do not have our law does not have the reach to bring them before the law as well. And there are certain things that we have, like as the creative industry, Viacom 18s and other broadcasters and other companies have actually partnered with law enforcement and created cells like MCDC, which is the Maharashtra Cyber Digital Crime Unit, to fight piracy. And we have been able to bring some of them to justice who are operating from within India, like the CEO of Top TV and Orient TV, who was arrested 4 months back in a joint operation where we were providing the information to MCDC, and MCDC made the arrest, and he's still in judicial custody right now. But what happens to those who operate from outside India and making available pirate services in India is the main issue that we are trying to tackle. Right now, for those kind of services, we cannot shut them down because they are not within within jurisdiction of India. And the only thing that we can do is approach court for John Doe orders or dynamic injunctions, directing ISPs to block the pirated online content. But it is like the game of whack-the-mole, where you just take down one link of pirated content, the same content comes up in another link. So it is becoming a vicious cycle. That's what's happening, and people sitting in foreign jurisdictions is just out of our reach. And even if you go into those countries and try to take action, the cost is so prohibitive that even corporates shy away from doing something like that. So serious issues and some immediate steps need to be brought in to address these problems. That is my view on this one.
Thank you for bringing that out so succinctly, Anil. When Radhe was released on the OTT platform, and within hours of its release, it was available on several other content provider sites, and even it was being actually shared by end users or fans by via Telegram and WhatsApp and other such means. Salman Khan actually took to Twitter to warn his fans not to engage in piracy. So let's hear this. Let's hear the response to my next question from a legal practitioner. Tanu, this question is to you. What are the legal recourses that are actually available to content providers or to content creators whose content becomes the subject of piracy, on different digital platforms? First in India, let's just deal with the Indian territory to start with. So how are they supposed to protect, or what are their recourses that they have once they find that their content, which is actually their revenue stream, is now freely available on other content and other digital platforms? What is their recourse according to you? How can they be? How should they reach out?
Thanks, Aazmeen, and thanks the AdValley team for having me here. I think Anil has really sort of broadly at least covered and sort of drawn the background here. But just, I mean, I think maybe from a practitioner's perspective, more specifically getting into the legalities of it. Look, when we talk of content, we talk of copyright, basically, which is the statutory protection for content, which is an intellectual property, right, or an intangible asset in that sense. And when we talk of piracy, just comparable to any real property, it's basically like theft of property, right, and theft of an intangible asset. And because it's akin to theft, our remedies under the framework are also sort of aligned to that. In terms of specific legal recourses, what is available today is under our Copyright Act. You have both civil and criminal remedies. A criminal remedy, again, because it's akin to a theft, it's considered as a cognizable offense, which means it's a non-bailable offense. And an offender could perhaps be imprisoned for up to 3 years, which is all in the statute. In terms of process, how do you initiate a criminal action? You file an FIR. The FIR forms the basis of an investigation, and then investigation then sort of leads to a charge sheet, which leads to a criminal proceeding before a magistrate or a court. On the civil side of things, you can file for a suit for damages and couple it with by seeking an injunctive relief, which is an in sort of interim and immediate relief. In more simpler terms, an injunction is basically an order from the court which sort of prevents a certain action or a certain activity, and in this case targeted to piracy. Now, over the years, like Anil was very rightly saying, practically what in the digital world specifically, what started happening is, people who are pirating and these infringers, and technology is advancing. So everyone's, innovating ways to pirate as well. What happens is that it's like a chain reaction. One infringer takes out a copy from somewhere. And then it suddenly, it's like a chain. It suddenly starts getting shared across different platforms, and nobody can really identify who is the initiator of this, right? Similarly, there will be one website where a certain pirated copy or unauthorized copy of a content is available. And the minute you enforce an injunction against that particular URL or a website, immediately after that, there will be another website hosting the same content. So what courts have done over the years, I think, is specifically in piracy or infringement actions, two different types of injunctions are being sought these days, and courts have been fairly liberal in granting those as well. One is called a John Doe order. It's simply sort of saying you can ask for an injunction against an unknown person, right? Because in the online world, you really don't know the identity of a person. You may be able to identify, let's say, a few websites, but you may not be able to identify all. So a John Doe order is, specifically then in that sense, operates against people who you have been able to identify and automatically against people who you haven't been able to identify. The injunction from a court's perspective as an order is operating against, everyone. It's up to you then, how you identify specific people and then, serve them a copy of the order and then enforce the injunction. So that's one part of it. The other bit, which I think Anil also mentioned, was a dynamic injunction. Simply said, dynamic injunction again is similar to a John Doe order, except that in a John Doe order, you sort of identify a specific entity. And so your injunction operates against a specific entity, whereas in a dynamic injunction, it operates against different URLs and different websites. So basically, you have an injunction against one website that is hosting unauthorized content, and then immediately there will be a mirror website. So when you get a dynamic injunction, your injunction is sort of operating against not just the original website, but also against mirror websites. I think these are all, what is available under the statutes today, the sort of remedies that people can seek. We have a fairly large team, sort of does this day in and day out. But I think piracy is a larger menace today. And like Anil is rightly saying, and I'm sure my co-panelists, Vishnu and Anamika, they'll also agree. It's a larger menace which sort of needs a more collective thought and action, which needs to sort of be beyond our legal processes and legal statutes. That's my take. But to sum it up, those are the broader remedies under our statutes today.
Thank you, Tanu. That was so insightful, especially for our guests who may not have a legal background, but who fret and fume whenever they have uploaded any new content which is original, and where they subsequently find that before they can monetize it adequately, it's already uploaded on several other content sharing sites where they have no control over. So this has been extremely helpful insofar as the Indian territory is concerned. My next question goes a little further beyond India, and I am going to invite Anamika to answer that. So what happens, because the internet is the World Wide Web, right? So nobody has any control over where you can find your content ultimately shared. So from that perspective, if a content creator finds that his or her content is now found beyond Indian sites, on global sites, and let's assume they're even able to find out on which URLs they are available, and they are able to find out that yes, these URLs are subject to international laws, then what is the recourse that such a content creator can have under the laws?
Thank you, Aazmeen. So yes, actually this piracy, so when we say there should be one law and the law should deal the piracy, it is impossible. It won't happen. So what it requires a collective effort. And when I talk about the collective effort, I am a lawyer of trade union as well. I am the lawyer at Screenwriter Association. So here I will say trade union or collective bargaining organization can play a very good role, because these organizations have a power, lots of members, so they can have a lobby with their counterpart outside India. Okay, so this is one way. For example, in India, you know that this certain pirated website has origin outside India. So for example, any South Asian country or anywhere, then trade union of your country can have talk with the trade union, because they are again facing similar problem. Their law cannot arrest a pirate which is operating from India. So here both of them can coordinate together, so that how can you mitigate the cost of litigation as well? Because when you sit in India and when you are dealing with outside firm or outside lawyers, lots of things you will be missing. But when you take help of your counterpart outside India, of course they will provide you those resources which you need to efficiently tackle this. So this is one approach. Other approach, I came across a very interesting way, which is right now happening and it is evolving, which is voluntarily agreement. For example, I just read that American Motion Picture Association, they have an agreement with several domain name providers. For example, they have an agreement with Donuts, Rediff, and these people. So whenever you come across, you have lots of complaint that this specific domain name is showing lots of pirated content. So in that case, if you have this voluntarily agreement, then those domain name can be suspended, it can be demoted, so that it does not clearly come in the search engine. And as Tanu and Anil, they said that today piracy is not just about just sharing one certain file to your other friends and just watch the film. They are operating as a huge business. For example, there are apps like Picasso or other apps where when you open that, lots of advertisement you will see. And this advertisement is not just Indian advertisement. You will see some foreign casino advertisement or some beauty brand advertisement and all. And they generally earn money through these advertisements as well. Again, this voluntarily contract, it helps in that way also. For example, in America, again, the Motion Picture Association, they have contract with advertisement bureau there. which just act as an oversighter, that if your member, if certain people who are associated with your advertisement agency, are they showing their advertisement on this illegitimate business sites? So if that is the same, what action can be taken? How you should not put money to those pirated, because they are earning without any investment. They are just like they're selling narcotic drug, and that too very openly. So this way also you can dismantle their business and slow down. Of course it requires a lot of research. It requires, because right now it is just on the evolving stage. Similarly, in the Australia, their association, they have an contract with search engine Google. So those lots of pirated site, if you inform the Google, give them relevant data that these are the pirated sites, they may demote them, and once they have demoted, they cannot come easily on the search engine. So these are the ways, the evolving ways through which you just try to, of course it is not an easy battle, it is a very tough battle, and entering into the contract with these giants are not very easy. But then I said that this cannot be done by one company. This can be done by collective effort, associations or lots of companies coming together and talking about it, and developing new technology, for example blockchain technology, NFT technology. These are also by if you invest lots in those technology, again it can carve out a way to find out what are the original sources, whether in India or outside India, because piracy cannot be seen as a territorial activity. It has to be look from the perspective of global menaces. So all this, through these specific ways, and cooperation and coordination along with the legislation will help you to figure out a way.
Thanks, Anamika. Tanu, would you like to add in or weigh in a little bit more, also over and above collaboration, as Anamika was alluding to, between countries and their trade unions or associations to kind of investigate where the content piracy actually originated from? As a lay consumer or as a lay content creator, or let's say if it is a company which is in India, which has found its content to be pirated on global sites, what is the way out for them, and how do they take recourse under the global laws in that sense?
Sure. Aazmeen, so okay, in terms of concepts, specific legal concepts, what is piracy, what is infringement, what are the remedies? The remedies are perhaps, different, let's say, sections and different provisions under different legislations. But at the end of the day, all common law jurisdictions largely operate on similar legal principles. Mostly all of our copyright laws and associated laws in terms of remedies, they all are subsets of treaties and conventions across countries. So in that sense, they all follow a similar system and a similar concept in terms of remedies as well. I think I do agree with Anamika that a lot of it in terms of just taking action can happen by associations across different countries collaborating with each other to take action. But I think ultimately your actions are in the form of injunctions only, right, at the moment. So, our laws are a little, as a legal remedy, you will be able to seek injunctive remedies. The other things are, for example, today, content creators and, a lot of these platforms also who host content, they invest a lot in rights management systems also. And I think Anil was also mentioning that earlier. Even in our Copyright Act, we have Section 65A, 65B, which specifically talks about platforms who have sort of implemented technological measures or security measures within their systems to manage and protect copyright. And you can, if you can prove that somebody has really gone ahead and tampered with your systems, with an intent to pirate or infringe, you can take action against them. So I would say that, from an international perspective, our laws and concepts are quite aligned in that sense. But it is not, piracy. I think like Anamika and Anil are both saying, it's become like a parallel economy, become like a parallel business. There are people who are investing, lots of money just creating this parallel business. So it needs effort of that kind at an international and a global level to really cover it.
Okay, thank you. Vishnu, would you like to just sort of put in your 2 bits on this as your thoughts on it?
Yeah, I think that Tanu covered the local aspects of enforcement well, and Anamika gave some very creative solutions. And my pulse on this is that this requires an out-of-the-box integrative approach of technology and law. And I will try and combine the 4th and 5th questions that you put for all of us. So if you know, we worked with lawyers in the US, in the European Union. We have clients who had issues in these jurisdictions, and then India, of course. So if you look at US as a jurisdiction, I mean, we were trying to figure out some statistics for some clients, and we figured out that over 80% of pirated content comes from illegal streaming services. This is a huge number to contend with. Given how developed that jurisdiction is in terms of technology, I'm not talking about enforcement. Howsoever rosy the picture is, it is tough to get injunctive relief and damages, even in the US, because the costs of getting that are prohibitive, as Anil seemed to indicate when he was talking. It is ridiculously prohibitive. The cost of procuring it may outrun the cost, awarded in the end. But the law does have some tooth there. For example, pirated music, can cost you as much as $750 minimum as damages per song. For example, if you were to have peer-to-peer music exchanges, up to $150,000 per song. The Millennium Copyright Act has stronger provisions in this particular respect. Very weirdly, they stopped the Stop Online Piracy Act some time ago, which was introduced in the US Senate. And I'm not sure why that happened, but ultimately, the judicial approach has not seemed to do, or has not seemed to work the wonders that it was supposed to work. Even in Europe, you had the e-commerce directive. I mean, just moving across the pond, and now they have this proposed Digital Services Act, which has a couple of very interesting concepts. One of them is that if there is a company which frequently experiences its content being stolen and being pirated, then it becomes like a trusted flagger and probably gets released under takedown mechanisms quickly under the proposed Digital Services Act. Likewise, I think jurisdictions need to work together to combine lists of, or create lists of repeated infringers as well, so that the action taken is faster at a digital level, not at the judicial enforcement level, but in terms of takedown mechanism, complaints to regulatory authorities, etc. If you just come back to India and you look at what Justice Patel said in his judgments a few years ago when he was talking of John Doe orders and injunctions, he seemed to tell content creators that you need to come up with something more than just apprehensions on which websites are carrying illegal content. He wanted evidence which showed that certain websites did carry specific infringing material. And even if you wanted an injunction in the future against the same website, a specific content creator had to show that his or her content had been previously carried on this particular network or website. What's ultimately going to happen is that, I think as one of the panelists in the previous discussion said, that technological investments have brought the downtime and the carryover time of broadcasts in these OTT platforms from years to weeks potentially. And that's the kind of investment that you need to make to figure out a holistic mechanism where technology can give you quick solutions, or at least a very solid database with which to work with. You know who's repeatedly carrying on infringement. It's not the small player. You could think of an aggressive US-like strategy where they went after the end users for some time. They gave it blitzkrieg publicity. So, small people exchanging peer-to-peer content, were fined huge amounts by courts based on complaints filed by content creators, original music creators, etc. And then that sort of deterred or scared other players. I mean, that was one tactic which was followed in the US. But ultimately in India, you've got to have the kind of coordination, and I'm going to totally digress here, the way financial and non-banking financial companies have. It's like you commit one financial default, and the Income Tax Office, the Reserve Bank of India, and all banking companies and non-banking financial institutions have a common database, which is how companies like CRISIL derive their data and their analysis from. So ultimately, it's got to be a cohesive kind of effort where someone commits one default, and that name should spread to all organizations who have an interest in ensuring that their content doesn't get pirated and carried over on pirated networks by the same party. You have to engage with TRAI and domain name registrars. As Anamika, I think, alluded to, coordination between the Motion Picture Association and DNRs in the US. Domain name registrars can play a very vital role in giving clear information on who the registrant is. And like it or not, it is not an easy job for pirators and infringers to keep registering domains and to keep creating identities which are distinct from what they created earlier. Now, why TRAI? TRAI is very important because ultimately, pirated content leads to about a quarter of the internet bandwidth available today being misused, right? And at the end of the day, it is in TRAI's benefit to ensure that bandwidth is actually shifted or focused on genuine content, which actually means that you have fewer disruptions, you have quicker internet available to end users, to companies, to intermediaries, etc. And at the end of the day, a more pleasant streaming experience, which actually can ensure that, so for example, if you provide TRAI with specific data, they can actually block specific users or specific companies who are known to have infringing material on their websites from using bandwidth. So it's going to be a cohesive effort between telecom companies, TRAI, content providers, platforms, regulatory authorities. Now, when all this cohesion will happen, you will actually have some bit of the infringers weeded away at the outset itself. Many of them tackled with the regulatory compliance mechanism, and ultimately really serious ones being taken to court.
Thank you, Vishnu.
I'm sorry, I have to interrupt in between, but we are running late. So can we consider that the last question?
Okay, sure.
Aazmeen?
Sure.
Thank you so much for all your efforts, your knowledge that you have shared with us. And I think this one issue needs immediate attention. I think you all agree to it. So thank you so much, all of you, for your wholehearted participation in the discussion. Thank you.